All right, good afternoon, everybody who is remaining here and those who are on the phone. This is our last program of the day. The bad news is that there is one more program before we all hover it over to the bar next door. The good news is it's a great program. We only have one speaker, so we won't take too much more of the time. I'm Jim Rubin. I'm partner at Dorsey, but I spent a significant part of my career at DOJ in the Environment Division, which is a key player in environmental enforcement, which we'll talk about in a few minutes. I work closely with the civil and criminal prosecutors, as well as agency officials and investigators at EPA and Interior, Agriculture, Commerce, other agencies. I also organize and taught programs around the world on the principles and techniques of enforcement. These days at Dorsey, I keep my clients out of enforcement proceedings as much as possible, and I've handled a number of internal investigations and voluntary disclosures, as well as settlements to avoid greater civil and criminal liability. One notable thing about DOJ, for those who are interested, is that most of its work is actually non-discretionary in the environmental field. It's defensive in nature. They represent lots of agencies, so they're defending those agencies in court. Only a small subset of its work, which is non-discretionary, is enforcement. And most of that's civil. Of the enforcement work they do there, most of the work that DOJ gets comes from EPA in the first place. It's referred to by the agency. In the criminal area, EPA is really the key agency for providing information for DOJ prosecutions. Thus, we're very fortunate to have in our last program today a chance for discussion and Q&A with Doug Parker, who until earlier this year directed the criminal division, investigation division at EPA. Doug began at EPA as a special agent in what's known as CID, or the Criminal Investigation Division, 24 years ago, and rose up the ranks and eventually became the director for 4 years. As a director, Doug oversaw a nationwide team of special agents and criminal analysts who were tasked with investigating the most serious environmental crimes affecting the American public, its environment, and U.S. commerce. He set the strategic direction of CID, oversaw the agency's criminal investigations, and coordinated senior-level investigative matters with DOJ and a broad group of law enforcement regulatory agencies. Doug was also responsible for briefing senior agency management and senior staff on Capitol Hill and served as a primary media spokesperson for the agency on criminal matters. Doug worked very closely along with DOJ with FBI, Homeland Security, and various state law enforcement agencies in carrying out national enforcement and Homeland Security issues. He was involved in overseeing investigative responses and criminal prosecution of some of the most prominent environmental matters of the last decade. You'll recognize a lot of these. Flint, Michigan, water crisis there, major industrial explosions, Chevron, Richmond Refinery, Duke Energy and TVA's coal ash issues, and, of course, the Deepwater Horizon investigation, and recently the Volkswagen defeat device case. Doug is now president of EW Strategies, a consulting firm that is part of the Earth and Water Group, and apparently is downstairs.
That's correct.
Very coincidence, huh? In this role, he utilizes his deep experience and expertise he's developed over these years to provide key insights and strategic advice to companies addressing their internal operations who may be facing scrutiny from governmental NGOs or other public officials looking for enforcement purposes. Doug is the guy to call when people come knocking at your door looking to investigate your company for environmental issues. Doug holds a BA from Colby College in Maine and MA in Public Policy from Georgetown University. So it's great to have Doug here. We've planned this last program as more of a discussion. I have a series of questions I'm going to ask Doug about. Covers a broad array of issues, both enforcement issues generally, how EPA and DOJ work together, and I'm going to put Doug on the spot and ask for a little prognostication about what EPA may be up to in the next couple of years. I'll open things up. If people have questions here in the audience here, if people have questions who are plugged in still, you can email them to me at Rubin, RUBIN.Jim, JIM @Dorsey.com, and I can ask those questions. Most important, there is a PowerPoint in the materials that Doug may refer to in his discussions. We don't have one on screen, but in your materials there is something he's put together that will cover some of these issues. As I said before, after we're done, there's a reception next door, so hopefully people can join us and have discussions there as well. So without further ado, let me throw out the first question to Doug. It's more of a baseline question. Now, describe a little bit about the role of EPA in civil and criminal investigation and enforcement. How does it get cases, and how does it work with DOJ in the process?
Sure. So I would say that among the distinctions between civil and criminal enforcement is an emphasis on planning versus reactive. Civil is a much more planned out process, enforcement priorities, focusing on sectors, and the criminal program tends to be more reactive, like it is in any law enforcement capacity. I would say that the reality is that the decisions in terms of identifying enforcement priorities, which is really EPA's roadmap moving forward in terms of what they think is important from an enforcement standpoint, is civilly driven as opposed to criminally driven. There's a couple of those initiatives that the criminal program engages in, but they, if it's involving municipal sewer overflows, that's not really going to be a criminal issue. That's kind of emblematic of the civil tilt in developing those priorities. A couple of other things. I would say that the ability for the assistant administrator, the political appointee who oversees the Office of Enforcement and Compliance Assistance, to weigh in is much more significant on civil enforcement than criminal enforcement. Criminal tends to be driven more by the special agents and leadership of CID and the Department of Justice, both the U.S. Attorney's Office and Maine Justice, the Environment and Natural Resource Division. And the political appointees at EPA are generally loath to engage in trying to kind of tip the scales, certainly on any specific investigations. Mm-hmm. They'll lay out priorities and certainly be engaged where they can, but they tend to be much more involved in driving the civil bus, if you will. So,
now what have been some of the leading enforcement initiatives coming out of EPA in the last several years?
Well, I think the most significant ones have been, I would say, the reactive issues. No one expected Flint, VW, and earlier on Deepwater Horizon. Right. Those took up a lot of the oxygen of both the civil and criminal sides, particularly Deepwater Horizon and still Volkswagen. I'd say on the civil side that there was a real focus on wet weather and national enforcement priorities, concentrated animal feeding operations, agricultural impacts on water. Those were in their enforcement priorities. Mm-hmm. And I would say the big kind of new thing over criminal enforcement has been, from a subject matter standpoint, it's been fraud in the renewable fuels market, which has exploded in the last 5 years. And then I would say responding to catastrophic incidents. 112R and the Clean Air Act. But as we've seen a series of ongoing catastrophic incidents, refinery explosions, pipeline issues, there's been a real effort to ramp up and be in a position to respond to those quickly.
Now you mentioned kind of the proactive, reactive, and really focusing criminal more on the reactive. How proactive is EPA in investigations and enforcement? I mean, is it something that more of a sitting back and waiting for things to come? Where do the cases mostly come from?
Well, on the criminal side, the primary pipeline for cases is state agencies. It's really not our partners in the EPA, although there are certainly significant cases that arise from there. Mm-hmm. And those are the boots on the ground. So they're seeing what's going on. So you are harvesting your leads because you're planting the seeds for them. Folks are out working with their state agencies, state law enforcement agencies, et cetera, and they're coming in that way. And then the overlay of that is identifying the most significant priorities. Fewer than, I would say of the leads that come in, well fewer than 20% are open as criminal investigations. There is far more work to consider than you can actually effectively work. Right. So while those contacts are being made, while information is coming in, we're always evaluating it to take on the most significant cases, excuse me, and also ones that can align with the agency priorities where they can. Sir?
Yes. You could bring in some valuable insight from outside the box. Most of us deal in securities and commodities.
Yep.
But you mentioned here about the impact of an effective corporate compliance system.
Yeah.
And I'm wondering what things you look to outside of the securities context in designing an effective compliance system that would lower the culpability index in any sentencing or penalty assessment?
Well, I think I'd start with what the building blocks are of a sound corporate compliance culture.
Yeah. What tools do you look to that would be inside of the normal box that we see with the PC board or the DOJ directives under the culpability index or many of the SEC releases? Maybe we should repeat the question.
Yeah, so the question is, stepping outside the immediate focus of EPA enforcement is trying to, what policies and strategies would corporations want to look at for building a potentially effective compliance culture?
Yeah, and what tools do you look to bring into your
Sure.
database?
So I would look at, I'll put it in the context of the environmental health and safety area, and then you can extrapolate from there. I think what we have seen is the times there are, the word incentive is critical, because when you look at how business units are incentivized and how managers are incentivized, that can tell you a lot about the corporate culture of an organization. Let me take a slight turn from that. One thing that we have seen that is foundational to effective compliance cultures is when the responsibility for compliance is spread throughout the organization. As we see a lot of folks in the environmental health and safety senior level, they have lonely jobs. They have the C-suite saying, why can't we permit, why does it take you 2 years to permit this? We have regulators nipping at their heels, and we have business unit leaders saying, I'm the sales guy, that's not my problem. So the most effective companies and corporations that we've seen are those that have integrated compliance metrics across their business units. So it's not just the compliance guy or compliance gal, whatever the issue is. The other culture piece I think that is worth looking at, and I think there's going to be people looking at this for years and years to come, is Volkswagen. The story is still not fully told on Volkswagen, but there was an extraordinarily intense culture or an intense focus on getting to a certain result. And that focus on getting to a certain result drowned out the ability for folks to make the right decision in terms of how they were reacting. What that means in the context of my perception of looking at Volkswagen is that it was, we are going to dominate this market in this particular sector, and that is non-negotiable. And that message filtered down to the engineers, software engineers, and not meeting that goal was not an acceptable part of the culture there. And that ultimately incentivized very bad behavior. So what we look at certainly are, is that compliance culture and responsibility diffuse around an organization? But we look at less, on the enforcement side, we look less at the tools. We looked at kind of metrics of what made this, what were the triggers, what I would call the 4 key enforcement triggers. And if those were present, those made for a much more likely target. And in one of the slides, I've got I talk about the 4 key enforcement triggers, and I think some of this can be laid across other white-collar areas. But in this case, one is significant environmental harm or public health impacts. Deceptive or misleading conduct goes across. Operating outside of the regulatory system, and repetitive violations. And repetitive violations, I think, gets part to the corporate culture as well.
Did Volkswagen have any form of an incentive or bonus program for reporting market risk, or I shouldn't say market risk, but enterprise risk?
The question was, for those to find out, whether Volkswagen had any institutional mechanisms for reporting market risk.
And the answer...
Enterprise risk.
Enterprise risk.
Yeah.
Which is different from financial risk.
Sure. The answer is, I don't know, but probably. But I think it was drowned out by the directive that came really from the tops of the organization for performance. So, there may have been elements of the organization that were certainly operating with facilities where that could occur, but the overriding directive, as I saw it, was thou shalt meet this goal.
Now, following up on that was a very good question, because it was leading to that ultimately is, are there particular recommendations you would give the companies to essentially, aside for making a more diffuse corporate culture, actually hard actions they can take in the review and in their policy making that would ensure this culture exists?
Well, I think, there are some, when you look at, when you go back to the area of incentives, I was sitting in on a presentation that a general counsel from a large company put on, a company that had endured a series of criminal investigations, and they looked at their compensation structure, and they looked at how the employees' retirement packages were driven by the last 3 years of performance at their specific facility. And what they found is that the senior managers at that facility then deprived that particular location of the capital expenditures and the investments that you need to ensure a safe and healthy workplace. So they looked certainly at that as an area. I think I go back to the area of diffusing EHS or compliance responsibilities through an organization. And I think the other thing, that the lens that executives and those advising them need to look through is when issues occur in the environmental space, there is going to be an extraordinarily deep exam on the related to the decision making and the financial decision making that occurs. Within that, I was speaking with a CEO of a company who was extraordinarily proud of the new accounting system that they had put in for X million or millions of dollars. And he went on, and he was his lens. He came up as an accountant, CFO, and now CEO. And then I asked him what he was spending on compliance, and there was a rather kind of befuddled look. But those are, where you put your treasure is going to be looked at in hindsight by federal prosecutors, investigators, enforcement folks. So I think, proactively, as you're looking at where do you apply resources, you've got to be cognizant that folks will be looking at through the lens of, if you spent here, why didn't you spend there? So being wise about how you apply those resources in the compliance space.
Thanks.
Can I ask another question?
Please ask as
Of
much
course.
as you want.
Are you aware of any companies that have undergone an audit where they have changed their internal reporting and protection from financial fraud to enterprise risk? And if so, what the impact has been on the culpability index?
I can't say that I personally have been. I think I think taking a broader look from an enterprise standpoint, or what we often refer to as an operational risk management approach, is simply wise, because it takes it out of simply, to me, the dollars and cents and the legitimate responsibilities you have to manage that, to a broader focus, which in the end I think is going to appear to be a more holistic approach if you're under scrutiny.
I'm going to put it more bluntly. So many stolen in the shower rooms in the state, it certainly had a detrimental impact
Yes.
on their financial condition.
Absolutely. I'll tell you a short fact on the VW case. The NGO that did the initial research on this spent about $70,000. And they did that because the premise that was that they wanted to prove to European governments, where there is widespread cheating in the emissions area, that, see, you can do it right. We've got these 3 Volkswagen vehicles, and we've tested them for for a month, driving up and down the Pacific Coast Highway. And they said, all of a sudden, the data wasn't adding up. And so this scrappy little NGO, which went on Craigslist to rent one of the vehicles, has cost Volkswagen a $14+ billion civil settlement, ongoing criminal liability, and who knows what in market share and long-term reputation. So,
That's just the United States.
right.
Well, let's follow up on that a little bit, because that's, we talked a little bit at the very beginning about getting some materials in from the state, but you mentioned the scrappy NGO. There's a lot of more scrappy NGOs out there. How do NGOs find out what's going on except for going on Craigslist? I think we talked a little bit about before them going on analytics. Why don't you talk a little bit about and particularly how analytics might play into the enterprise risk here?
Yeah. So I think I would characterize myself as not a practitioner, but an evangelist for data science and analytics and transparency. To me, the application of those principles, concepts, tools is the absolute game changer in this sector and will be for years to come. Specifically, what that means is advances in data science analytics have taken, have essentially shrink-wrapped large problems and large issues and made them more accessible. A bunch of years ago, I had folks from an NGO came into my office as the director of CID, and they said, we have spent months and months through FOIA and other tools, and we have gotten the discharge monitoring reports from this series of coal companies. And our eager young law students have sat in the room, and they've analyzed them, and we've done Excel spreadsheets, and based on that, here is the information that now tells you that they are violating the Clean Water Act. That work can now be done in hours.
Well, this is for those who are in the initiative. These are reports that the company does on its own on the requirements of law. So they get hung up on their own data.
And I think so. What went on within the fence line is no longer within the fence line. Data and the ability to identify activity through even merging social media, government data, private sector data, can now be used by NGOs, the government, competitors, to gain a quote-unquote picture of the truth that heretofore took months and months to assemble.
Again, thinking broader than just the United States, many of our clients do business around the world, and we keep talking about effective corporate compliance systems.
Yep.
And we look to U.S. guidance. Where do I look for that in the European Union?
The question is about the equivalent search for guidance on a compliance culture in the European Union.
That's a good question, and one that I'm not, I don't have a good answer for. I think that, the VW example in many ways, to me, was, I realized kind of the lagging cultural issues in terms of compliance in the European Union until I really looked at the comparison of what went on here and there. So I don't have a great answer beyond that. We have some great, principles, approaches, and metrics to actually model here. I mean, one of the views that I have in this era of is the United States falling behind, is China taking all our jobs? We are the absolute, unequivocal leader in understanding environmental compliance and how to get there. We are, bar none. We have the world's greatest experts. So what I would hope is that we could be, to some degree, a model, but I can't speak to what the specific options are if you're in the EU.
One idea might be one of the organizations that EPA put a leading role with is an organization called INECE, the International Network of Environmental Compliance Enforcement Officials, INECE. Yep. So it's now run out of Environmental Law Institute, but it's a website. You go on there, they have yearly meetings and papers written by folks from all over the country, but a lot of EU enforcement people are there. The UK and the Dutch are probably in the lead in this area, and of course Germans probably have caught up a lot now because of VW, but it's a good place to start and look for papers and names of organizations. There'll be a lot of material written about the EU there. That's a good start. Yeah,
and I would echo that the Dutch and the UK, to me, are the European leaders.
Now, so I'm going to jump a little bit ahead on the prognostication part of it. So these NGOs clearly have played a pretty leading role in building up some of the cases. They're out there. They've got the ability in some of these environmental statutes to sue on their own, but not in the criminal world. Only the U.S. can bring a case. So do you see that as a increasing phenomenon, given the potential for EPA to kind of come into more conservative management? Yes,
I think the NGOs are essentially going to be on steroids for the coming years in terms of their approach to environmental enforcement, compliance, adversarial litigation, and I think that you'll see a lot of that in citizen suits, things like that. But I think you'll see them going after from public campaigns against companies to try and drive public opinion. I think you'll see them aggressively using data science, analytics, transparency, those tools to bring information that, quote-unquote, has to be looked at by the EPA if they feel there's a reticence. Now, I personally don't feel that EPA enforcement is going away. I think that there is, when the transition team begins to turn its attention to the EPA, there's certainly going to be a change in the regulatory approach. It has been going quite quickly. And I think the brakes will be tapped on that aggressively. But I do think when you look at it from a self-interested standpoint, that you have to be able, as a government, to respond. And, all the rhetoric on the campaign trail, we're going to dismantle the agency, climate change is a hoax, that can go away when there is a major event. If there is another Deepwater Horizon, you are going to be turning to the Coast Guard and the EPA to respond. If there is another Katrina, you're going to be turning to FEMA and the EPA and the Coast Guard. If Charleston, West Virginia loses its water again for weeks, you're going to be turning to the EPA. So I think from a rational standpoint, the folks who are coming in will understand that you need to have a credible response capability when these issues arise. That being said, I think there will be a very big change in kind of the regulatory approach. Yes?
What role did you see in U.S. authorities that say there was a Deepwater Horizon in Mexican waters inside the Gulf?
So the question is, there's a accident or spill in the Gulf in the Mexican side. What role the U.S. authorities can play in an event like that?
I think the best and most appropriate role would be aggressive cross-border coordination, which organizations like the Coast Guard are very good at. There may be litigation. I don't see any criminal hooks from a jurisdictional standpoint, but I would anticipate that at the end of the day, when you have a crisis, you're going to have to cooperate. And one of the things that we're fortunate about is the military State Department, those liaison functions are pretty embedded, and they're really put to a test when there's a crisis. But I think it would be more of that kind of environmental remediation response piece, possible litigation, but it'd be hard for me to see, based on that, kind of a criminal hook per se.
Yeah, the United States certainly would have the responsibilities of dealing with that. The question will be how they pay for it. There is precedent on the civil side for the United States to go after a foreign corporation that had an impact in the United States from an activity in Canada. It's a Canadian issue with Lake Roosevelt and the tech chemical smelter. So it's not happens a lot, but that's merely a monetary thing. You couldn't go after them in criminal court.
Done in the way of an NGO bringing an action, a preemptive action against, say, a Mexican corporation that's selling oil in the United States, directly or indirectly, that is violating EPA standards.
So the question is, if there's a violation in the United States from a foreign corporation, what role can the NGOs play in that?
Well, I don't know. They could certainly fundraise off of it. Yeah, from that perspective. I think that my experience in terms of kind of the interplay of, I'll give you one example. There was a Mexican-based enterprise that was connected to a Texas-based enterprise that mixed, I believe it was called coke or gas, kind of a really low quality petroleum product. Pretty dangerous, pretty nasty stuff. And they ultimately had to, they realized they had a problem in terms of disposing of some waste associated with that, which was transferred at sea. They went to Rotterdam and they said, no, thank you. The ship ended up tragically going to the Ivory Coast, where they found people for, fractions of pennies on the dollar who disposed of the material. And ultimately killed 8 or 10 folks who came in contact with it, injured folks. Very, very bad situation. What that led to was a pretty unsatisfying result. A long-term investigation where ultimately, jurisdiction could not be identified, but ongoing international litigation. Some European, I believe the Dutch went after some of the folks, but it was not it was a messy a tragic situation and a very messy situation in terms of holding folks accountable. Now, that doesn't mean that NGOs can't, drill down and identify those "quote unquote" responsible, and have their figure out where they can litigate in that country, or initiate public shaming campaigns against those associated. But it's always pretty murky when you're dealing with that set of facts. And as Jim can attest, when you're dealing with environmental law and convicting someone of an environmental crime, it is a very complicated set of facts and science-based issues and regulatory issues to navigate in the first place.
And a steep burden. The NGOs in the United States right now could bring an action against a company from anywhere in the world who brought an activity in the United States and violated the Water Act or the Air Act. If it's a significant enough violation, chances are the EPA will be there first or take the case. But the NGOs can do that, and they can't make a fortune off it, but they can get attorney's fees and costs if they win the case. So it's part of the citizen enforcement mechanisms of most of our laws, but they're all civil.
Is there any companies as a way to level the playing field with regard to environmental costs, since we're good at mitigating the risk, and our companies are in competition, say, with companies in Mexico or some other country that are importing goods? That's where my questions are going.
Yeah, I can't think of a corporation that brought a citizen suit on any given basis. It's not how they would do business. But there are other ways of trying to level the playing field, including trying to bolster strong EPA enforcement. Some of the cases that are brought to EPA are not by the citizens. Sometimes they're brought by the companies.
We've had dozens of times companies feel like they're getting cheated, and they will bring that to the EPA's attention. They want their fingerprints generally completely off of the disclosures as best they can, but that is a fair, not uncommon approach.
And that's a key point, I guess. When Doug was talking about how enforcement's not going to go away, the question really is what are the principles EPA is looking for enforcement? One of them, I assume, is leveling the playing field and removing the benefit, so that it really, the argument to be made to any head of EPA is, you need to have this program because the people who are using good corporate culture need to have a reward for it, not lose because someone who's not meeting the law is actually a cheaper deal. But so what would you be looking for, and kind of what are the underlying bedrock principles of enforcement generally? And then I guess next to that, I want to get into, first I want to read the numbers of
yes.
for those who are doing a CLE. Panel 4 is KXW510 for those who are on CLE. And my question is, particularly if a company is trying to consider what it's going to do next because it has had a violation, what are the issues that EPA most cares about for enforcement, and then more specifically between criminal and civil enforcement? What are
sure.
looking for?
So I think what is an important principle for the EPA is that if you is the ability to voluntarily disclose and fix the pollution issue. I think it never behooves a company when they identify significant environmental violations to try and that would be of knowing interest to the EPA or the Department of Justice or the various state agency to withhold that information. I just think it never makes sense. Now, that doesn't mean every time you have, you've spilled a gallon of gas, you need to pick up the phone. But I think being thoughtful about that is really important. They don't want pollution to pay. They want a level playing field. And they ultimately don't want the American taxpayer to have to pick up the tab for improper private conduct. Now, in terms of differences between civil and criminal, I'd kind of go back to those enforcement triggers, but really think of it in two buckets: harm and conduct. Was there egregious harm? And egregious harm doesn't always equal criminal conduct, but it can be a trigger. And was there conduct that was deceptive, ongoing, misleading? Those are the issues that kind of separate civil from criminal. There are times it honestly can be hard to distinguish. One of the first steps in any criminal investigation when defense counsel has been retained and you actually have formal discussions with the Department of Justice is an effort that we cynically talk to on the agent side as massaging it to civil. Really, this is just a civil matter. And the criminal investigator's job, if the facts merited it, was to identify those significant factors that tipped the balance to making this a criminal case, and one that ultimately 12 jurors with no background in environmental protection would understand. And as part of that, I will tell one of the tricks that agents focused on was always trying to drive what we characterize as a Title 18 angle to the case: lying, cheating, and stealing. Don't make this about a science class. Make this about someone who did wrong, someone who lied, someone who cheated. And so that was a very important part of our investigative approach, if the facts were there to prove it.
All right, so massaging is one way of saying it. I prefer to think of it as trying to focus on the most exculpatory facts of the client, but let's look
and I now do as well, Jim. I do as well.
but let's look at that for a second. So, I take what you said about it. It's better to pass information on than to keep it, because even if you don't have an obligation to provide it under the statute, not providing it could be concealment. You're lying and cheating and stealing. Company has to figure out whether to disclose something or not, and it's worried there could be criminal violations. I mean, what does it want to do with EPA at that point? It actually could be found criminally. It makes a determination. It doesn't know if it will or not. And what does it do? And what can it do to make sure that it's massaged or at least avoids criminal liability to the most extent possible?
Well, I think there's a couple of approaches. Strategically, if you often there's overlap. Generally, there's overlap between the state and federal authorities, and it's wise for counsel to make a strategic decision if you've made the decision to voluntarily disclose to which entity, be it state or federal, makes more sense. And I think that can be a very significant decision. And then I think I would also encourage folks to have as much of the investigation, the facts identified internally through an internal investigation, obviously covered through in a privileged manner, so that as the attorney, as the client, there are as few surprises as possible when you come and make that. Bad news doesn't get better, as everyone knows. And so I think making, understanding as full a story as you can, consistent with the facts and the people involved prior, making the wise choice on where this information needs to go, and doing it as expeditiously as possible.
That's a key. The last point of expedition is pretty key, because a lot of the EPA policies actually require fairly aggressive reporting in a short period of time. So how's the balance? I mean, if is it a better thing to spend more time trying to get all the facts down if it means you're not going to be able to take advantage of some of the disclosure policies?
I think there's this 21. One of the triggers is this 21-day rule, and that's really hard to meet if you wanna do justice to understanding what went on. And my take, certainly I'm not speaking in any way on agency policy, but my take is I'd rather get it right than done quickly, because I think surprises down the road have the tendency to erode the credibility of the client if premature disclosures are made that ultimately, the agency or the department scratches their head and say, "Why didn't you tell us this 6 weeks ago or 2 months ago?"
And what are the benefits in the first place? We recommended disclosure, but what will that help get from EPA? What can EPA actually offer, especially if there's a potential criminal action?
Well, I think the broad cooperation, it really focuses in all concepts on penalty mitigation. And that might, it's obviously fact-driven, but that might be anything from, that's going to tip the balance to a civil resolution, or it may be in an individual and corporate liability based on the facts. It may limit individual liability. So I think, obviously if a matter arises, you have to deal with the messy facts that are there, and some may just not work very well. but ultimately having a detailed investigation and being as upfront as the client will permit you to be, I think are generally the best strategies.
Question?
If you decide to go to the state to make your trial, what factors should you look for in determining when the Fed will step in 3 months?
The question is, if you're thinking about going to the state for disclosure, what factors should you consider regarding when the feds might come into preemptive state? And I guess one question is, do the feds preempt the state?
They do, but rarely. So it's a great question. If it is viewed, and I can remember one instance recently, it was related to conduct in the energy sector, where a deal with the state, what we felt was so egregious that we, in our words, Bigfooted the state. So I think what you have to do as counsel is really look at the landscape and think, like, we can't be walking on. If there is significant conduct and it's identified at the state level, or you're working with a good state program, you need to be careful. You need to be honest with yourselves about whether a traffic ticket is really appropriate for the conduct, because those are the cases where ultimately it can be viewed as a little too cute, and that can lead to federal intervention.
Now, you mentioned something before about the individual and the corporation. I wanted to explore a little bit more of that in the few minutes we have left. There is a well-known memo out there, I think you're probably referring to it before, without the name of the Yates memo out of DOJ, that talks about criminal enforcement for individuals versus corporations. I guess could you explain a little bit about EPA's focus on when it wants to pursue an individual versus a corporation, and when they want to do both in terms of civil and criminal enforcement?
Sure. So to give you kind of a flavor of where the program's gone over the last 30 years, in the mid-'80s, well over 80% of the defendants were corporate-only cases. 20% were individuals. That's flipped now. I think it's 80. Last year was 82% of the defendants were individuals and 18% corporations. Many of those cases were not corporate-only. The mantra is you always want to go after the individual because that's what individuals, as we know, are the ones who make the decisions, and that is what really drives deterrence. So the Yates memo for those operating in the environmental crimes, natural resource enforcement area was, a reiteration of longstanding policy and approach. I will say that it is often hard to get from the bad act to the C-suite. It doesn't always work that way. And so it's not always appropriate to say we're going to go right to the top. But I can tell you that the Yates memo has added a point of emphasis to it and in areas of focus. And I think that, that CEOs and senior managers should take note of it. I think that in the decisions is not just expecting that we're going to find an email that the CEO of this multi-billion-dollar publicly traded company said, dump that hazardous waste in the river. It doesn't work that way, obviously. But methodically reviewing emails, looking at decisions on where companies have made investments, looking at innocuous, what might have been innocuous emails, can help build a culture and approach that can help lead to potentially charging folks very high up the line. I bet most folks listening know the phrase, something along, it's time for some traffic problems. That phrase,
New Jersey.
If you're in New Jersey, that phrase helped land a woman multiple convictions in the Bridgegate trial. Now, her attorneys had a very different view on what those words meant. But to me, it demonstrates the absolute power and importance of limited and effective communication electronically, because those are where folks, agents, analysts, prosecutors will be looking to try and reverse engineer folks thinking at the highest levels to identify whether they have culpability.
Now let's flip that back to the question you had before about corporate culture. Given this focus on hoping to find individuals involved in that, what are the recommendations to companies to make sure that while there might be diffuse management responsibilities, folks are immunizing themselves from finding themselves being shackled by the federal agents and the corporate C-suites?
So in terms of whether diffuse responsibility helps immunize them, I think first of all, if you're operating a large organization with multiple moving parts, there's going to be diffuse responsibility. If you are operating, any of the Fortune 500 companies, that's generally the case. So you can look at that as a benefit, but it is you also have to understand, as I mentioned, I spoke with this CEO. Financial decisions, where you're putting your treasure, where you're putting your time, are also indications, and they are a way to kind of sometimes short circuit the multiple layers of management in between. So, financial decisions, where you invest compliance resources, stray comments, stray emails, all of those. Folks, and it's not just that you're if you're a corporate executive that whatever is on your email server, expect that not only are your texts going to be analyzed and looked at, but your Facebook page, if you have one, for that you wanted to put something up about your kid when they graduated from high school. All of these areas of information, and that's another part of the growth in technology analytics. All those areas can be merged to get a picture, ideally a more clear picture of conduct.
Now, it's getting to be the end of the period. I'm going to give anyone else a chance to ask a question. I have one I'd leave with, but if other folks want to ask questions, go ahead.
The PowerPoint you didn't actually put out because computers. There's one thing you say, you address the importance of letting EPA tell you what it's going to do, pay attention to national enforcement. With the change of administration coming, should we expect those enforcement issues to hold? I mean, you're supposed to do for a 3-year period, but we've got Trump coming in who apparently doesn't like a lot of what EPA has been doing for the last few years.
So the question is, on the PowerPoint, there was a reference to paying attention to where the agency is going on its own initiatives. These initiatives last several years. The question is what might expect to see in the new administration in terms of initiatives. Are these going to carry over from the Obama administration? Will the new administration have new initiatives, and what should companies be looking for?
Great question, and I think you're onto something. If I were to look at the enforcement initiatives, the two that would stick out, three would stick out. And the focus on CAFOs, concentrated animal feeding operations, their impact on waterways, and energy extraction. Those are two constituencies that I think will want to weigh in. And so, they can, the new assistant administrator can make that change. Doesn't mean there won't be cases in those areas, but there could be tweaks in those. Conversely, if you look at the issue with chemical, I'd have to look at it, chemical plants, chemical safety. What that came from is the President's executive order on chemical safety. Deputy Attorney General Yates also put out a memo talking about the importance of focusing on worker safety. That, I think, will stay, and I think that focus will continue. And the reason being, I think it's an initiative that has broad appeal. We want people to be safe when they go to work. We don't want people to have to operate in unsafe conditions. Frankly, we don't want people to go to work and get blown up. It's just that simple. And what the EPA and DOJ have seen, there's been a long-term coalescing in their thinking, and that is if you have environmental degradation and you probably have worker safety issues and vice versa. There's a strong correlation there. And you'll see that both OSHA, EPA, and Department of Justice, although they haven't eliminated the data silos, they have begun to diminish. And so you're seeing a lot of cross-pollinating of information. I think that'll continue, and I think that, frankly, will accelerate And so then both agencies and the Department of Justice can make better, more focused decisions on targeting. And I think if you look at the recent case, I think it was KTX Limited case down in Southern or Eastern District of Texas, 2 or 3 worker death case. Folks were engaged in hot work, didn't have the right permit, may have lied about it. That exemplifies the kind of cases that I think will continue and that you'll see, elements of in the national enforcement initiatives.
Thank you. Any other questions? Well, and I didn't see any from the email, so thank you very much for the time. And it sounds like we should head next door, and those who are online can find their own libations. Thank you very much.
Great, thanks. Yeah, thank you.
Doug, Jim, thank you. Well, appreciate that. For everybody out there, we'd like to thank you for listening into the forum for this year. We hope that you've enjoyed what the presentations are. What we tried to do was give you a cross-section of what the different agencies in town are doing so that you could see what the trends are, because it's the trends that are really going to carry forward and that you want to be aware of. So hopefully we put you ahead of the curve. Have a good night. Thank you.